Throughout last month, when we were watching Mounk Tounk on the stand, everybody, including myself, was like, bruh, that last day across, Miss Love is trying to send that man to prison. Well, it turns out, check it out. State of Georgia versus Antonio Sledge. State's motion and petition to revoke probation. The state of Georgia, by and through Fonnie T. Willis, District Attorney for the Atlanta Judicial Circuit of Georgia, and the undersigned Chief Deputy District Attorney Adam Abate, hereby moves this honorable court to revoke the defendant's probation in the above style manner in accordance with OCGA 42-8-34. 1. In other authority in support of this motion, the state presents the following to the court. 1. Plea of guilty by defendant on December 28, 2022. On December 28, 2022, the defendant pleaded guilty to conspiracy to violate the Racketeer Influence and Corrupt Organizations Act and possession of a firearm by a convicted felon. Chief Judge Earl Glanville subsequently sentenced him to 30 years of probation. The general and special conditions of probation were detailed in the Fonnie Willis deposition sentence sheet filed on that date, Exhibit 8. Number 2, special conditions of defendant's sentence. Chief Judge Glanville imposed several special conditions on the defendant's probation, including the requirement that he fully adhere to all terms of the negotiated agreement. Any failure to comply with these terms will be considered a violation of the agreement. Other pertinence to this motion are the following special conditions. Defendant shall abide in fully by each and all of the terms of this negotiated agreement. Defendant's failure to abide by any term of this agreement shall constitute a violation of the agreement. Defendant shall testify truthfully about all matters relating to this case upon which he is questioned at any trial or judicial proceeding stemming from the facts alleged in this indictment. In accordance with testifying truthfully about all matters relating to this case, defendant acknowledges that each and all of the statements contained within the defendant's factual acknowledgement sections of this agreement are true. Defendant shall fully testify truthfully about each statement contained within defendant's factual acknowledgments, and any matters related to this case when asked to do so in any proceeding related to the facts alleged in this indictment. Number 3, defendant violated special conditions of his probation. The defendant has violated all the special conditions of his sentence outlined above on September 4th, 2024. He was called to testify in the trial of this case. When his testimony continuing through September 6, 2024, during which he underwent both direct and cross-examination, during his testimony, the defendant directly contradicted the special conditions of his plea agreement by disavowing the factual acknowledgments he had sworn were accurate and true during the plea hearing on December 28, 2022. At that time, he had the opportunity to correct or clarify any statements in the factual acknowledgment before affirming their truth under oath. He also confirmed that he fully understood the agreement and had discussed it in detail with his chosen attorney, Derek Wright, T. 13 through 20. Most importantly, the defendant acknowledged that he understood that any violation of the special conditions of his plea agreement could lead to the revocation of his probation, with the district attorney recommending the maximum sentence allowed by law in the Georgia Department of Corrections, T. 18. He confirmed both in writing and verbally that he entered the plea agreement freely, knowingly, and voluntarily without any force, threat, or coercion, T20. It is evident that defendant knowingly and willfully violated the special conditions of his negotiated plea agreement with the intent to disrupt the trial of this case. Therefore, the state of Georgia requests that this petition to revoke probation be scheduled for an evidentiary hearing and the defendant be ordered to appear before this court to explain why his probated sentence should not be revoked in its entirety. Respectfully submitted this 9th day of December, 2024, Adam Abate, Chief Deputy and District Attorney. Now, I know what y'all was thinking because I was thinking it too. Well, what was in that plea deal that was so special? Because you know as well as I do, if they putting that up there, they got to come with a little bit of actual factual. Now, here's what they added, right? It's a 61-page filing, right? And so what they basically are doing or telling the judge is here's his damn plea deal. You know what I'm saying? So they want to make sure that they throw all of this stuff in. They're using his plea deal as an exhibit, right? So current charges, count 1 and count 30, right? Conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm, which is insane because essentially you're not even saying that you caught him with a gun. You're saying, oh, he did all these things with a gun. And that boils down to count 1 being 15 to serve on probation, and then 30 is sentenced and withheld until the completion of the initial trial of this case. After the initial trial of this case, provided defendant has complied with the special conditions outlined in sections B, C, D, F, and I of section 3, special conditions of sentence of this plea agreement, the state agrees that defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. That's basically pleading no contest, and you only really pleading no contest so that you ain't getting sued down the line civilly. That's how I understand it. There's more to it, but that's the best way I can basically say it. And here's the funnier part. If you look right here, 1 of 7 plea agreement, state of Georgia versus Antonio Sledge, aka Mounk Tounk. Like, I ain't gonna lie, I got a nickname, Seti Nash, but I don't want you putting my nickname on there. So let's go to his factual acknowledgments. He said that Young Slime Life, aka YSL, is an organization made up of 3 or more members or associates who share common identifiers that include but are not limited to colors, hand signals, and terminology, who have committed crimes intended to increase the notoriety, street credibility, and reputation of YSL. All right, he signaled that. The defendant has been a member of Associated YSL since 2012. Well, in the indictment, and this is the part where if his lawyer is any good, he can say, well, we already have evidence that's contradicting the whole Young Thug part of this, because his testimony says, hey, we started this way back when, 2012. Y'all trying to bring up something from 2015, 2014. Well, this is 2 years before that. So y'all wrong on this. All right, so while associated with YSL and the support expressed loyalty to YSL, defendant and co-defendant Demekion Garland and Quindarius Zachary appeared in a video with another person. Well, I'm gonna be fair. You had Lil D, Quindarius Zachary, and you had him up on there basically saying this was not about no YSL BS. This is about a girl. And Lil D even said that on a freaking video. So y'all was wrong on that. So y'all gave a wrong deal on that part. His lawyer definitely gonna have to argue that one. On or about April 28, 2015, as reflected in the Fulton County indictment, defendant and fellow YSL associate Demekion Garland and Quindarius Zachary committed a drive-by shooting using a firearm. Defendant wielded in the video reference at part 3 of the section, targeted family members of a rival gang. All right. Defendant and fellow YSL associates committed the drive-by shooting reference to section 3 and to increase the notoriety, reputation, and fear of YSL. I'm sorry, I didn't see that. I didn't get that out of there. But when you signed it, you're saying, yeah, that's what we did it for. So this really fall on him. Defendant admitted committing and was convicted of aggravated assault and participation in criminal street gang activity, among other charges, for his participation in a drive-by shooting. So all of this crap, right? Well, that little bit of crap basically is saying that this is what it was, but Ms. Love and them already proved in court that that's actually not what it was for his participation in drive-by. Okay. Defendant was told by another YSL associate that immediately after the murder, Donovan Thomas Jr. YSL associates met at McDonald's on Cleveland Avenue in Atlanta to discuss the murder. See, that's the part right there where they're getting messed up at. Let's say, but then it's crazy because you was told this, so there's really no proof. Like, that's the part where it kind of get real Mickey and tricky. July 10th, after the murder, Donovan Thomas, defendant and YSL associates gathered at the home of Jeffrey Williams, aka Young Thug, who gave defendant and other YSL associates cash money to lay low. Well, what is lay low supposed to mean when you literally had 2 people, including this individual, who were proven not to have committed the murder of Donovan Thomas? You can argue that Young Thug understood that it's about to get real weird around here, so I might want to protect my people. So he kind of screwed with all of this shit that they just go through saying he defendant's sentencing and acknowledgement. He understands that he violates any provision or any special condition of this plea agreement. The district attorney can and will use the contents of the document agreement during judicial proceeding. Defendant understands fully if he violates any provision or any special condition of this plea deal, his probation sentence may be revoked in its entirety. It doesn't say will. So the lawyer is definitely going to argue that. And defendant understands fully that any violation of any provision or any special needs of the plea agreement will result in the defendant sentence on count 30 of the indictment, and the district attorney will recommend defendant serves maximum sentence allowed by law. So defendant understands fully that if prior to the conclusion of the initial trial of this case, defendant fails to refuse to testify to any fact that he acknowledges in his plea agreement, such as failure or refusal nullifies any promise made by the district attorney to null pros count 30 of this indictment. So You're not necessarily saying, because if we go back, right, let's wrap this up to the top part. Where's that? Excuse me. Count 30 right here is possession. So you're not even trying to get count 1. They're saying count 30, right? And then what she said about it, sentencing withheld until the completion of the initial trial of this case. After the initial trial of this case, provided the defendant has complied with special conditions outlined in sections B, C, D, F, and I. So you're really saying B is going to say you got to testify about all the matters. C says in accordance with testifying truthfully. D says defendant should truthfully testify about the statement. And what do they say? F shall commit no criminal acts. E, I'm assuming that has to be in there. Yeah, ain't got no guns. And then I, defendant relinquishes any Fifth Amendment right related to any statement contained with defendant's factual acknowledgments. So, yeah. You're really going with B and C? You know what I'm saying? I don't even understand why the other stuff had to be up in there, but whatever. So, yeah, bro, this is all the transcript of what happened that day. He was in there with the yes, ma'am. Do you speak the English language? Yes, ma'am. Do you understand that you're charged with the following offenses? Yes, ma'am. All of that crap. So, yeah, bro. Is Mounk Tounk going to jail? Well, let's further discuss something.
Now, let's be fair, square, obvious, and honest, right? This was really some get-back game. Now, granted, Miss Love kind of screwed herself a little bit, and I'll further divulge in a little bit. But Miss Love, you did this. I believe that other attorney 100%. If I'm Mounk Tounk, but after this, I'm firing him. And Mounk Tounk, if you don't turn into like a pastor or a freaking youth leader or something like that, if you don't get your shit together, bruh, I ain't gonna hold you. You deserve everything that come to you after this. Now, I do believe this RICO is a bunch of bullshit, but it doesn't matter what I think. It doesn't matter what the millions of people think. It only matters what Fonnie Willis and her office presented to the damn grand jury and ultimately into the judge and to the state of Georgia and the county of Fulton as well. So ultimately, that's what matters, not us outsiders, as much as we like to pretend, myself included. But, bro, you better figure this shit out quick. We knew it. See, the problem with certain people is they'll see something and try to replicate it. One of the worst things about this whole entire trial is there has been superstardom created out of people. And I'm not hating on Lil Woody or anything like that. But the unfortunate part of Lil Woody's testimony was that as raw and as many emotions and as many twists and turns and all of that stuff that happened, the very next witness that we had was going to fall under a bunch of bullshit. Just were. They were going to fall under the, can you be the next Lil Woody, whether they wanted to or not. So there's that. Then you have this thing, aka the plea deal, hanging above your head. And the plea deal basically is saying to the public, hey, bro, you looked out for yourself. Which ultimately, that's true. A plea deal is for yourself, unless the whole entire gang says, we all sign off on this. Just like how Woody Nelson 15 years ago had got caught with like, I think, half a pound of weed and literally had like 10 people with him. So you know what they did? All 10 of them, they said that this is my weed. And so they were all charged with misdemeanors instead of a felony. Because they said we all put into it, we all smoked this weed, so it is what it is. You had to divvy it up. This is how much I put on it, this is whatever. Those things get argued. So when we see this shit right here happen in court, it's called a red herring for a reason.
May be impeached by contradiction in several ways. Close questioning to elicit concessions of errors in testimony during direct, questioning a witness about the substance or implications of evidence already produced during the case to suggest contradictions, confronting the witness with his or her own contradictory prior statements, or calling another witness, or introducing other extrinsic contradicting evidence. Generally speaking, the admission of extrinsic evidence for contradiction impeachment is restricted to non-collateral matters, so that evidence that impeaches by contradiction and is not collateral can be both substantively admissible as well as admissible for its impeachment value. And that is coming from Baylor, Behler versus Hanlon, Hanlon, 199 FRD 553. And then the parenthetical is surveying numerous commentaries. Judge, with respect to Mr. Sledge, the reason that I began my statements to the court about what it is that he said, and will then go into what his lawyer said. When I asked his lawyer about plea negotiations on the heels of Mr. Sledge, not just saying he was told he could get up and tell his truth, but on cross-examination, he was asked repeatedly through the use of allowable leading questions. These weren't your words. You didn't write it. You didn't understand it. You didn't know what you were signing. You felt like you could come in here and tell your truth. You signed it regardless. I'm not directly quoting, but essentially, even though it wasn't true, you signed it. And things of that nature were elicited during cross. You signed it because you wanted to get out to go see your sick mom, things like that. You were in Fulton County Blues. That's the only reason you signed it. These aren't your words. These are only the state's words. So all of those questions were intended to attack the credibility of the veracity of the statement that Mr. Sledge made on December 28, 2022, when he signed the plea agreement. And Mr. Sledge acquiesced to all of those attacks, essentially asserting through his sort of obfuscations and running back and pulling back my truth. I don't understand. I don't recall. I don't remember saying that. That isn't true. And his pointing out at the state's request the factual acknowledgments that he now asserts were inaccurate or not completely true. He allowed himself and the cross-examining attorney to, in front of the jury, completely question or to undermine the credibility of the statement that he made and his own credibility at the time that he made the statement. So as the court has already instructed the jury that the inconsistent statements of a witness are also substantive evidence that may be considered against other persons on trial. Can the court hear me okay?
Yeah.
All right. So as the court has already instructed the jury that it can now consider that statement as substantive evidence, what we've seen is an attempt by the defense to destroy the jury's faith in the credibility or veracity of that statement made by Mr. Sledge on December 28, 2022. So when questions were posed to his attorney regarding Mr. Sledge's understanding of those acknowledgments and sentencing agreements, on the one hand, after he made clear that though he's a friend of both sides, he's a defense attorney through and through, Mr. Wright, though he did clear it up, he seemed to, his answers on cross-examination, there were some things that were not true. There were some things we didn't agree to. He was kind of vague with it. And it took belaboring point by point for him to even acknowledge, hey, number 3, number 8, these are the only 2 anybody took issue with. So at this point, Your Honor, I believe that the iterations that were presented to Mr. Wright and to his client per his words are important because it is further evidence that corroborates Mr. Sledge's understanding of and his understanding of the final plea agreement that is 18S and 444Y, and his ability to effectively engage in and have an active hand in that final document that he signed on December 28, 2022. It points not only, it demonstrates not only the inconsistencies of Mr. Sledge's testimony, but his outright perjury regarding his purported lack of ability to have any say in what that final document asserted that he signed. It is illustrative of the fact that he actually did have the ability to tell the state what he felt wasn't true and what parts he wanted changed. And I think that our position is that it is relevant in showing or allowing the jury to judge the credibility of statements Mr. Sledge has made on the stand versus the credibility of the statement that he made on December 28, 2022. The statute that I cited earlier, it substantiates our position that the representations that Mr. Sledge made under oath on December 28, 2022 were part of a long and detailed negotiation and refinement that Mr. Sledge himself took part in. As we I think at this point, 24-1-104 might become relevant. That's the one I brought up earlier that didn't have any bearing on what we were talking about. But in as much as 24-1-104 speaks to the code section not limiting the right of a party to introduce before the jury evidence relevant to weight or credibility, we believe that this particular evidence allows the jury, it is pertinent evidence that they should be allowed to see, to understand fully what was put before Mr. Sledge, what he did dispute, what he did not dispute, and so that they can compare it with what he finally agreed to and make a better determination about the truth of the statements he made on December 28th after that, which I believe was 453, but I'll check my notes to ensure that that's the case. So in as much as number one, he's saying, okay, there's no caveat, there's no, oh, hey, we need to, okay. So number two, obviously Mr. Sledge agreed to number two, but there is an additional, they formed about 3 years before Peanut was shot, him offering up that kind of information, Mr. Sledge offering up that kind of information. He is nowhere in there is he asserting it's a record label.
All right, well, nowhere in his factual acknowledgement on number two is it asserted what YSL is. It just says defendant has been a member and or associate of YSL since blank.
Right.
So he wouldn't need to say, and by the way, it's not a gang.
I agree with that. Also, but in number one, where we say what it is,
Yeah.
we don't use the word gang. We say something, we use specific language that he's perfectly okay with. And then in number two, he makes no effort to, qualify anything as he did on the stand multiple times.
Okay, well, as we all know, the case law holds that it's actually not illegal to be a member of a criminal street gang. It's only illegal to commit crimes in furtherance of it. Well, to commit crimes, period. And then it makes it a gang
What makes it a gang is a
violation
crime.
to commit crimes in furtherance.
And that's why number one is
Right. And so, I mean, number one is whatever number one is, but that number two says, oh, by the way, it was about 3 years before Peanut was shot.
It's that he's offering information, and I'm going to defer whatever the court's ruling is, but it's that he's offering additional information. He's comfortable enough to say
I think that is okay. I think it was about 3 years beforehand, so it must have been about 2012.
Okay.
So three.
Number three.
Didn't we read that into the record?
We did. We read the response Mr. Wright gave.
Okay.
And I believe we read.
We did read into the record.
If I make it, I believe we read as well the portion of 452 that was number three, and then the final. I think we read number threes into the record, just so that the court is hearing what I believe is the full truth. We read not just that, but I asked him to read what he responded to and then how we changed it for him.
We read at least the final version of number three.
We
many,
did.
many times.
Okay.
So number four,
Um,
back on the email by Mr. Wright.
okay.
We never read that in, right?
So
I'll
number
remind-
four,
I'll remind
we did
the
not.
court that we approached about number four. There were obvious problems with number four that were inadmissible. We were told to stay away from number four. The state was told to stay away from number four for obvious reasons. There's all sorts of speculation in there. And now, after being told to stay away from it, and we were told to stay away from it, and we did not address it during cross-examination, now, after witnesses have testified, the state's seeking to admit a document that has number four in it. And it's just, I don't know what we're doing.
Okay.
You know what I mean?
Number five is not even relevant, right?
Your Honor, if I may just circle back briefly, as it relates to number four, there was an objection to it. We followed the court's instruction. We did not ask him about it. And when the issue that I have with number four not being addressed here is, more importantly, I don't know how an assertion that the witness did not adopt is prejudicial when he is not, he denies it and we change it and we take it out, that he was planning, he had personal knowledge that they were planning. That is powerful because it is a material fact that
He doesn't
denies.
have personal knowledge
That's
that they were planning it.
Judge, that's the point that I'm making, that he says, I did not know that. The fact that something that,
Even saying I did not know that is sort of like,
Or that's not
well,
true.
it's true, but I didn't know it.
No, he's saying that's not true. He is
No,
saying
he's
that-
not. He's saying, I don't know. I think maybe XYZ. That is not coming in.
That's the ultimate one that he
I
signed.
know.
But showing, yes, it is. It
I
is.
know.
Showing that he was untruthful and letting the jury decide. Why are you telling stories about that? About seeing a prior version, we believe is strong evidence that allows them to judge his credibility, why he's saying what he's saying, any bias he may or may not have, and help them to determine the truth of which statement they should believe. So we would ask that the court, I don't know, revive its prior ruling, revive the ruling that the court made.
Denied. Let's move on.
Now, here's what I believe. Here's what I 100% believe. Mounk Tounk ultimately, more than likely, I got to give myself that out. More than likely, he's not going to go to prison. But this is a stiff warning for everybody else. If you don't think that what she's doing, Miss Love, because she tried to get a bait to sign for it, or a body, I don't know how to say cuz name, and I really don't care. You don't think her name, Miss Love's name, wasn't off of that for a reason? Come on now. Miss Love's name was off of that for a reason. Because she didn't want the public to think, oh man, guess what? Miss Love is pissed off. She's not going to do this. She's not going to do that. Or Miss Love may have superior intellect and been like, listen, and this goes to my other thing. I know I can't argue this in front of the judge. So let me get somebody else to argue this in front of the judge. Because if I do it, she 100% going to be like, hell no, you should have prepped your witness better. You should have did this and did this better and all this crap. The problem that a bait is going to have is that your ass wasn't there. Unless I didn't know. Now, if he was there, then he was there. But then again, still, he wasn't the one to examine Antonio Sledge. So she wasn't the one that was able to basically talk to Mounk Tounk. If he wasn't, pardon me, and wasn't the one crossing him, it should really be the person that was crossing him to do it up. And that's where I think Miss Love screwed up with this damn motion to get Mounk Tounk thrown in jail. Now, is it possible that he goes to jail for 28 years? Hell yeah. And you wonder why 28 years? Because basically been on probation for almost 2. And by the time this get looked at and all this shit, it's going to be basically 2 years. So with that being said, can he get the 28 years? 100%. He definitely could. Throw his ass right there. But I ultimately don't think so. I think this really serves as a siren to everybody else that's about to come up and testify. Like, hey, y'all play ball or get kicked in the balls. Now, there are plea deals that are more favorable. Like at Duke's, his plea deal, he's not going to be screwed. So fuck him. We ain't worried about no damn Duke. We worried about everybody else that's coming up afterwards, because only one person has a good plea deal. The others was like, nah, let me get the hell out. That fuck this shit, I'm out. Yeah, that's what they on. So other than Duke, everybody else is screwed. So I don't know what to tell y'all, but hey, we 4,000 away from that $1,000 giveaway. There have been people, and I'm gonna tell you right now, I might even make a short out of it, going back to them old videos, commenting. So please make sure you subscribe to our bell, stay notified, share to keep your people aware. But make sure the biggest indicator that you were here is that you go back, and I don't care what you type. You can type Sadie Nash, you ain't that handsome. Sadie Nash, you are that handsome. Hey, I want my 1,000. I'm not telling y'all what to say, but this is a giveaway. So be an active subscriber. And there you go. Bro, I think probably by the end of this week, it's going to be down to 3K. If it's down to 3K, y'all better hop on it now. Because after this money is gone, we're going to be giving away some PlayStations out here. So, yeah, because is anybody rocking with the Xbox? Let me know in the comments what y'all, yeah. But what do y'all think about this video? Let me know you like it, dislike it. What's your thoughts? Do you think Mounk Tounk is going to jail? Going to prison, pardon me. He ain't going to jail. He's going straight to the pen. So do y'all think he's going to the pen, or do you think, you know what? Nah, they just doing this because it's sour grapes and they know they messed up, and everybody else is just coming there and call, I don't recall. Because some of y'all gonna be like, well, why didn't Lil D do all this? Because Lil D wasn't in on the RICO. He was literally subpoenaed. So that's why he gets to holler, I don't recall and all that stuff. That's the hard part that some people ain't gonna be able to grasp. If you signed that plea deal and you say you're going to factually acknowledge this shit, that means vocally too. You ain't just about to write it on this paper and then switch it up. Hell nah. You don't get that Mounk Tounk treatment. But if your ass signed that paper and you said, oh yeah, this, and this, and this, and this, that's the one thing that Mounk Tounk has in his favor is that he said YSL was in 2012. So all of this shit, and then, like I said, they proved that it actually was over a girl while they shot up that house. But other than that, shit, I ain't gonna hold you. Everybody else seemed to be screwed. But that's why we do the case. We have to wait. So I'm not gonna get ahead of myself, and I advise y'all not to. But let me know your thoughts on this one.